Outside the courthouse here, I'm wondering, you said no expression. Was there any discernible reaction on the attorneys for, that would be Pat Cotter for Mike McClain and Dan Collins for Mike Madigan? Did they seem to show any kind of reaction at all?
You know, while it was a mistrial in those counts, and we'll have to wait and see what happens next, I think they too aren't really sure what is going to happen if the government will move to retry McClain and Madigan for those 6 counts. Remember, McClain has already been convicted in the ComEd 4 trial. That might be enough for federal prosecutors. When that note was brought back to the courtroom at 10 this morning, and the jury said they've agreed on 17 counts, cannot agree on 12. They don't believe they'll be able to move forward with further agreement. All of the attorneys really seemed okay with that. They said they were fine accepting a partial verdict. Federal prosecutors seemed happy with that. And of course, so did the defense attorneys. So we will see. I think it will be more telling when Madigan and McClain come downstairs. We haven't seen them yet. We understand they are still upstairs with their attorneys. So their expressions and whether any of their attorneys choose to talk to the media downstairs, that will be very telling.
You know, Dane was just talking to Ron Safer, saying that first charge, that racketeering charge, was the big one, and that would be the one you would think the government really wanted to get them on, basically alleging that Madigan's entire political organization was a criminal racket. And it's interesting that the jurors could not come to an agreement on that. Basically, some jurors allegedly or apparently believing that his political organization wasn't, or there wasn't proof beyond reasonable doubt that it was just a criminal organization or a racket, that there was legitimate political or government purposes for the 13th Ward organization existing. So I wonder if that plays into the government's decision at all, and if these other charges, obviously they all carry concurrent sentences with them, and that's usually the strategy here for the feds. They throw everything up against the wall, so to speak, 23 charges here, because they know that some of them aren't going to stick, and it's multiple bites at the apple. So each of these charges do carry potential jail time, but I just wonder, not getting him on that racketeering charge, whether that plays into the sentencing, whether that plays into the prosecution desire to let sleeping dogs lie, or to go back and retry some of those charges. In the Blagojevich case, they hung on that first trial. They basically hung on everything, and so the government had to go and streamline its case and bring a much simpler case. This was a very complicated case. I remember just thinking to myself, this is a lot of sort of in the weeds type of things that the jury has to be apprised of here, taking notes on ComEd and how power rates get set, and how, you know, just day-to-day political interactions could be really tedious at times. So, I mean, a credit to the jurors for sitting there for over 3 months and listening to all these witnesses and tapes. Kasey?
And Paris, you know, we should also add, it was unusual and really remarkable that none of the jurors at any point missed a day. They weren't absent. None of them dropped out. None of them were removed. We often see that in cases where jurors are removed for one reason or the other. In this case, all of those jurors were dedicated. They showed up every day. None of them dropped out during the deliberation process. And Paris, to your point about that racketeering charge, think back to last Friday. We had an inclination that the jury might be stuck on some charges when they sent that note to the courtroom. It asked, is bona fide salary a valuable thing, and should bona fide salary be considered a thing of value? Experts, including Ron Safer, who we've been chatting with today, explained that the jury was probably trying to figure out where the line was between legitimate conduct and bribery And as we now know, with these 6 counts, 6 for each man, so 12 total, with the jury being deadlocked on today, really shows that they were having trouble figuring out what was bribery, what was legitimate conduct. As you mentioned, this was a tedious case. There was so much evidence, so much testimony from witnesses. The jury really had to be attentive throughout this process, and they did. And, you know, the judge could have said, go back, keep deliberating, try again. They did not do that. The attorneys seemed happy with the counts that they had agreed on. And again, just to reiterate, Madigan found guilty on 10 counts, not guilty on 7, and the remaining 6 charges deadlocked.